Hi everybody, so now I am going to discuss the questions of Indian Evidence Act. So let's get started. The first question is, as per section 3, the fact means and includes. Okay, statement kisuman desu kuntu correct hoy. So fact means and includes only state of things. No, this is not correct. Any mental condition of which any person is not conscious, this is also not correct. Anything, state of things, relation of things capable of being perceived by the senses, this is correct. Any mental condition of which any person is conscious, this is also correct. So statement 3 and 4 is correct. So the option D. And fact may be classified as physical and psychological, positive and negative facts. Second question, presumption of law is mandatory. Okay, that's why the court is bound to draw presumption of law. And he karone court presumption of law to ignore koribo noare. So presumption of law or presumption of fact or difference to apnaloke sabo. Presumption of law is mandatory and presumption of fact is discretionary. And the presumption of law derived on the established judicial norms and they have become part of the legal rules. Next question, the term same transaction has been defined nowhere in the Evidence Act. So the option D is the correct option. Both educated confusion hoise both bhabise to 6 boli 6 under define kora hoise boli bhabise kintu 6 under a term to mention kora ase kintu section 6 to same transaction tat kuno definition provide kora nai. Section 6 talks about that facts which form part of the same transaction are relevant. Question number 29. The question of relevancy can be raised at any stage. The statement is true. Yes, the question of relevancy can be raised at any stage. And the question of relevancy is a question of law to be decided by the judge. And the question of relevancy should be decided when raised. It should not be reserved until the date of the judgment in the case. Question number 30, ইয়াত এটা কন্ডিশন দিয়া হৈছে যে যদি এভিডেন্স তো পার্টলি রিলেভেন্ট হয় বা পার্টলি ইরিলেভেন্ট হয় তো কিছুমান তেনেকুৱা ধৰণৰ সিচুৱেশ্যনত কি ডিসিশন ল'ব কি কৰিব তাত ওকে ফাৰ্স্ট কন্ডিশনটো দিয়া হৈছে যে where the situation দিয়া হৈছে যে where the irrelevant evidence is so mixed up with the relevant evidence as to make it impossible to separate one from the other, the whole of the evidence is to be rejected. Yes, this is correct. যদি irrelevant evidence to relevant evidence হৰ লগত এনেকে mix up হৈ থাকে যে irrelevant part to relevant part to পৰা separate কৰাটো impossible হয় তেতিয়া whole evidence to কি কৰিব reject কৰিব. So this statement is correct. Where the relevant material is quite independent of the irrelevant material, the relevant will be admitted and the other part will be rejected. যদি relevant material বা যিখিনি relevant evidence সেইখিনি যদি independent হয় irrelevant part টো পৰা বা irrelevant part টো পৰা separate কৰিব পাৰি তেতিয়াহলে কোৰ্টে relevant part টো admit কৰিব আৰু irrelevant যিটো part সেইটো reject কৰিব. So both the situations are correct. So the answer is C, both A and B. Question number 31, relevancy of facts forming part of the same transaction is mentioned under section 6. Okay, and the principle underlining section 6 is sometimes termed as res gesti. Okay, res gesti to apnalok short note ahi thake hetu pohibor section 6 to bhalke buji pelai pohibo. Our section 6 or under even hearsay statements are admissible under this section if they form part of the same transaction. Okay. Question number 32. Which section of the Indian Evidence Act talks about the relevancy of facts in terms of cause or effect of the fact in issue? So the correct option is D, section 7. So facts which cause or effect of the fact in issue or of relevant fact are relevant as per section 7 of Indian Evidence Act. Question number 33. In the Indian Evidence Act, the question of relevancy has been dealt with under section 5 to 55. And date of admissibility under section 56 onwards. So the correct option is C, 5 to 55 and 56. So jibilakor jihokolor evidence sector relevancy আৰু admissibility এই দুটা concept ভালকে clear হৈছে বুজি পাইছে. So আপোনালোকৰ evidence act খনৰ 60% concept clear বুলি ধৰিব পাৰি. Okay, 60% 70% বুলি ধৰিব পাৰি. যেটা main বস্তু relevancy and admissibility. So jibilake বুজি পাইছে বহুত ভাল কথা ভালকে বুজি পেলাই পঢ়িছে যোনে বুজি পোৱা নাই বা problem হৈছে আপোনালোকে ভালকে বুজি পেলাই পঢ়িবলৈ try কৰিব. Question number 35. Motive preparation, previous or subsequent conduct is provided under which of the following section of the Indian Evidence Act? So that is section 8. Etu question ahiye thake apnalokor section 8 or Next question, the theory of agency is the basic principle of which of the following section of the Indian Evidence Act? So the correct option is C, section 10 or basic principle or theory of agency. So section 10 deals with the admissibility of evidence in a conspiracy case. And the only condition for application of the rule of section 10 is that there must be reasonable ground to believe that two or more persons have conspired together to commit an offense. So section 10 applicable however the main condition to which is a কোৰ্টৰ এটি বিলিভ কৰাৰ ৰিজনেবল গ্ৰাউণ্ড থাকিব লাগিব যে দুজন বা তাতকৈ বেছি পাৰ্চনে লগ হৈ পেলাই কিবা এটা অফেন্স কমিট কৰাৰ কাৰণে কনস্পিৰেচি কৰিছে আৰু প্ৰত্যেকজন কনস্পাইৰেটৰকে সেই গ্ৰুপটোৰ বা এছ'চিয়েশ্যনটো এজেণ্ট হিচাপে কনচিডাৰ কৰে দ্যাটছ ৱাই দ্য থিয়ৰী অফ এজেঞ্চি ইজ দ্য বেচিক প্ৰিন্সিপল অফ সেকশ্যন 10. So every conspirator is the agent of this association in carrying out the object of conspiracy. Okay, and under section 10 anything done or written by any one of the conspirator in respect of their common intention যদি কোনোবা এজন সেই কনস্পিৰেচি কৰা গ্ৰুপটোৰ কোনোবা যিকোনো এজন কনস্পিৰেটৰে যদি কিবা এটা কৰে এনিথিং ডান বা ৰিটেন কৰে ইন ৰেসপেক্ট অফ দেয়াৰ কমন ইন্টেনশন তেতিয়াহলে সেইটো গোটেই কেজন কনস্পিৰেটৰ এগেইনষ্টত কি হ'ব ৰিলিভেন্ট দ্যাট শুড বি ৰিলিভেন্ট ফেক্ট এগেইনষ্ট each of the conspirator অকল যে গোটেই কেজন কনস্পিৰেটৰ এগেইনষ্ট ৰিলিভেন্ট হ'ব তেনেকুৱা নহয় ইভেন সেই কনস্পিৰেচিটো প্ৰুভ কৰাৰ ক্ষেত্ৰতো হেতু কি হ'ব ৰিলিভেন্ট হ'ব so anything done or written by any one of the conspirator in respect of their common intention as relevant fact not only against each of the conspirator but proving the conspiracy itself okay next question in the chapter of relevancy of fact which section is described as residuary section so the answer is section 11 of residuary section hisabe describe kora hoy okay aru section 11 to apnaloke bhalke pohibo ta jutu duta clause ase he clause duta bhalke buji pohibole chesta koribo aru section 11 to aru bahut questions hai jodi ko LIV is governed by which section so LIV is also governed by section 11 and section 11 is controlled by which section section 11 is controlled by section 32 where the evidence consists of the statement of person who are dead or cannot be found kintu ei rule tur khetrot kisuman exceptions ase he exceptions pur apnalke bhalke pohibo logote section 11 or jituta clauses ase he clause duta buji pele pohibo question number 37 section deals with all cases in which mental state is involved so section 14 deals with all cases in which mental state is involved okay that's why the section 11 is a general section boli koa hoy it is dealing with all cases in which mental state is involved whereas section D speaks out only those cases where the question is where a particular act is accidental or intentional so section 15 section 15 e hebilake speak kore jot question to arise hoise hey particular act to accidental hoy ne incidental hoy okay so the answer is section 14 and 15 so monot rakhibo section 14 he hokolobur case logot deal kore jot mental state involved thake ar section 15 he hebur case pick kore jot question to arise hoise hey particular act to accidental hoy ne intentional hoy okay question number 38 section 23 deals with admission in civil cases when relevant and when oral admission as to contents of the documents are relevant it is provided under section 22 and where oral as to the contents of electronic records are relevant it is provided under section 22A 22A to I think information technology act order insert kora hoise evidence act ebar apnaloke bhalke sai pela confirm kori lobo okay question number 39 confession caused by inducement threat or promises contained in section 24 section 24 is also very important etu bhalke poribo or section 24 confession word to Indian evidence sector for the first time or karone appear hoise okay aru that confession ki what is judicial confession extrajudicial confession difference between judicial and extrajudicial confession heburu bhalke poribo retracted confession poribo retracted confession opor apnalor short note ahi thake question okay next question to retracted confession important so a retracted confession statement dia hoise kuntu correct hoy alabat can be made solely the basis of conviction no this is not correct cannot be made solely the basis of conviction under any circumstances no cannot be made solely the basis of conviction unless the same is corroborated so this is correct so a retracted confession cannot be made solely the basis of conviction unless the same is corroborated now what is retracted confession means suppose accused person এজনে ট্রায়াল বিগিন হোৱাৰ আগতে এটা ষ্টেটমেণ্ট দিলে সেই ষ্টেটমেণ্টটোৰ দ্বাৰাই তেওঁ যে কিবা এটা অফেন্স এটা কমিট কৰিছে সেইটো এডমিট কৰিলে বাট হুইচ হি ৰেপুডিয়েটছ এট দ্য ট্ৰায়াল কিন্তু ট্ৰায়ালৰ সময়ত সেইটো কি কৰে ৰেপুডিয়েট কৰে ডেট ইজ কল্ড দ্য ৰিট্ৰেক্টেড কনফেশ্যন Question number 41. Which section of the Indian Evidence Act controls section 24, 25 and 26? So the correct option is A, 27. Okay. আৰু যদি এনেকে কোৱেশ্চন আহে যে ইয়াত আমি হতিলো যে 27 এ কোনবিলাক সেকশনস কন্ট্ৰোল কৰে ইন্ডিয়ান এভিডেন্স এক্টৰ যদি কোৱেশ্চন ফৰ্ম হয় যে the scope of section 27 is restricted by which article of the Indian Constitution, then the answer will be article 20 clause 3. So scope of section 27 is restricted by article 20 clause 3 of the Indian Constitution. ভালকে পঢ়ি চাব বাটুকলালৰ কিতাপখন ধুনিয়াকে দিয়া আছে ওকে আৰু আৰ্টিকেল 20 ৰ ওপৰত ক্লজ 1 2 3 ৰ ওপৰত সেপাৰেট মোৰ ভিডিও আছে চাই লব পাৰে Question number 42. Where a person making a dying declaration survives, his statement will not be admissible. Question number 43. The opinion of persons specially skilled in some science, art, foreign law, and identity of handwriting and finger impression is relevant under section 45. So 45 deals with opinion, expert opinion. Section 53 and 54 deals with, section 52 deals with in criminal cases, previous good character relevant, and section 54 deals with previous bad character not relevant except in reply. So D. Question number 45. Fact which need not be proved. কোনবিলাকৰ ক্ষেত্ৰত fact proof কৰা দৰকাৰ নহয় তো fact judicial noticeable yes fact of which court must take judicial notice this is also correct so the correct option is C both A and B. So fact judicial noticeable that is provided under section 56 and facts of which court must take judicial notice that is provided under section 57. Okay. Next question. Oral evidence under section 60 must be direct only. Question number 47. Consider the following statement. Yat kisuma statement diya ase kuntu statement true hoy. So copies made from or compared with the original is a primary evidence. No, this is not original evidence. This is secondary evidence. Okay. So this statement is wrong. Where a judgment originally written in English was translated into Urdu and the judge signed the translation, it was held that it was secondary evidence of its contents. No, this statement is also wrong because it was a primary evidence of its contents. Counterparts of documents as against the parties who did not execute them is a secondary evidence. Okay, so this is correct. Statement 4. Oral accounts of the contents of a document given by some persons who has himself seen it, it is a secondary evidence. Yes, this is also correct. So 3 and 4. So option D, 3 and 4. Question number 48. আৰু আগৰ কোৱেশ্চনটোত আপোনালোকে যেটো ইয়াত মই প্ৰাইমাৰী আৰু সেকেন্ডাৰী এভিডেন্সৰ কথা কলো সো প্ৰাইমাৰী এভিডেন্সটো আছে সেকশন 62 দিস প্ৰাইমাৰী এভিডেন্স এন্ড সেকশন 63 আছে secondary evidence primary evidence আৰু secondary evidence তো আপোনালোকে ভালকে চাই থব ডিফাৰেন্সও আহে আৰু লগতে আপোনালোকৰ শৰ্ট নোটও আহে Question number 48. Which section of the Indian Evidence Act is based on what is sometimes described as the best evidence rule? 80, 88, 90, none. So here eta on hoy that is so the correct option is none. So correct answer to hoise here best evidence rule will sometimes describe kora hai kuntu section that is section 91. Okay, so section 91 is sometimes described as best evidence rule. Best evidence about the contents of a document is the document itself. Okay, our section 91 is excludes the oral evidence for proving the contents of a document, except in cases where secondary evidence is allowed to be laid under the relevant provisions of the Indian Evidence Act. So section 91 or 92 report ma separately video banam that I elaborately discuss korim ya dori ma discuss no koru. Okay. Section 49 match the following. So 101 that is deals with burden of proof. 110 that is deals with burden of proof as to ownership. 113b presumption as to dowry debt. 115 estoppel. So estoppel to apnaloke bhalke poribo estoppel tor upoto questions ahe. So yat A3 B4 C2 and D1. So B. Last question. Consider the following statements. So leading questions may be ইয়াত কিছুমান মই স্টেটমেন্ট দিছো হে স্টেটমেন্ট বোৰ্ড ইয়াত আমি ট্ৰু টু নহয় কোনবিলাক ৰং আমি হেবিলাক আমি বাছি উলিয়াব লাগে ওকে আৰু এনেকুৱা ধৰণৰ কোৱেশ্চনছ মই আগতেও দিছিলো যে ৰং এনে সাধাৰণ এনেকুৱা ধৰণৰ কোৱেশ্চন মই দিও কনসিডাৰ দা ফলোইং স্টেটমেন্ট তাত কাৰেক্ট স্টেটমেন্ট মই বাছি উলিয়াবলৈ দিও সো আগত যিবিলাক তেনেকুৱা ধৰণৰ আৰু কোৱেশ্চন দিছো কিছুমানত মই এনেকৈ দিছো যে ৰং স্টেটমেন্টটো বাছি উলিয়াব দিছো বহুতৰে মই যেতিয়া question answer sheet bro apnalokor evaluate koriso tat dekhiso bohote ki korise that wrong sentence to wrong statement to mo choose koribo diso tat correct to apnaloke options ot apnaloke mark kori dise he karone ki actually etu confuse hoy jay kitia ba question to apnaloke bhalke prothomote pohi lobo cool hoy pela pohi lobo okay kitate kenuka khetot ki hoy jona bostu ki hoy jay apnalokor bhul hoy jay karon ya wrong basi uliabol diso tat apnaloke correct gita di tamne concept to apnaloke clear ase kintu wrong and right question that মই কি হদিছো হেতু হতে ভালকে সোৱা নাই লিখুতে আপোনালোকৰ ভুল হৈ গল হঠাতে ওকে সো এনেকুৱা ধৰণৰ সিলি মিস্টেকস বিলাক নকৰিব হঠাই কুল হৈ খুব ভালকে পঢ়ি পেলা তাৰ পিছত আনসাৰটো লিখিব কাৰণ কিয়নো OMR sheetsত আপোনালোকে এবাৰ যেতিয়া আপোনালোকে সাৰ্কেলটো আপোনালোকে কৰিব হেতুটাৰ পিছত আপুনি আৰু কাৰেক্ট কৰিব নোৱাৰে গতিকে প্ৰথমতে কৰতে ভাবিচিন্তি কুল হৈ পেলা ভালকে কৰিব ওকে so the first statement is leading questions may be asked in re-examination so this is not correct kyono leading questions may be asked in cross examination under section 143 ase okay when they may be asked that means when leading questions may be asked evidence is weight not counted this statement is correct etur upor apnalokor ebar means to question ahisile explain koribo disile so moi definitely etur upor to moi video eta bonam so kunto section ase etia monoko apnaloke nije sai lobo okay witness to character may be cross examined only okay this statement is also not correct this is wrong because witness to character may be cross examined and re-examined not cross examined only cross examine koribo pare re-examine koribo pare a witness is allowed to refresh his memory by any writing this is correct under section 159 ot ase etu so yara ami wrong statement jehetu amak wrong statement ami choose koribo lai kuntu palo 1 2 wrong and 3 so the correct option is C 1 and 3 so ekhini asil amar evidence or 25 questions so amar gote ekhini paper or amar mock test bur complete hol so agor video tut moi koisu so 100 marks or mock test tor kane apnalke porok ar date tu moi apnalok 7 by 8 days or agot apnalok moi janai dim ar logote apnaloke reasoning o kom sabo reasoning jenukwa dhorno ahi ase dhorok thenukwa tar upor base kori pelai moi dim so number system e hok ba analogy ahise ba kiteba syllogism ahise tenukwa dhorno dim apnaloke sai lok okay gotike apnaloke prepare kori thakok pohi thakok eneke porok jate bhabilok monote je apnalokor AGS grade 3 date to announce korise teneke porok ekebare exam dibo buliye mane release exam date to dise teneke monote bhabilok teneke apnaloke preparation to solakson tapsot moi date to 7 by 8 days ago apnalok groupot moi janai dim aru current affairs er kotha jetu moi koisilo hetu jodi moi prepare koribo paru aji hoyto kali di dibo paru oha kali di dibo paru groupot ami nohole tar ke dudin ba 3 din pisoto apnalok moi PDF format 2020 questions ke apnalok moi every week di thakim okay aru jodi GK question lage janabo তেতিয়া মই দি দিব পাৰিম মোক মেসেজ এটা কৈ দিব মই দি দিম আপোনালোকক okay so this is for today thank you